other side too. So there you go. Okay.
I wouldn't exactly call him a rookie, but
You can.
yeah. Well, Your Honors, I'm appearing on behalf of the appellant Aaron Malone as his appointed counsel. I'm asking to reserve 3 minutes for rebuttal, please.
Thank you, ma'am.
Thank you. Mr. Malone was convicted of the first-degree murder of Hako Velic in 2008. He exhausted his appeals and filed a petition for post-conviction relief, which was denied. And then in 2022, Mr. Malone filed a petition for post-conviction DNA analysis. So this is an appeal from the post-conviction court's summary denial of that petition. So I raised 5 issues in my brief, and I'd like to spend the majority of my time focusing on the 5th issue, where I argued that the trial court erred by failing to appoint new counsel to amend Mr. Malone's pro se petition after Mr. Malone's post-conviction counsel gave the court notice that he was leaving the jurisdiction. Now, Mr. Malone does not have a constitutional right to post-conviction counsel, and a post-conviction court can, in some circumstances, dismiss a post-conviction petition without appointing counsel. However, once the post-conviction court decided to appoint counsel for Mr. Malone, rather than just dismissing his petition after preliminary consideration, Mr. Malone then had a statutory right to an attorney who would either file an amended petition on his behalf or consult with him before deciding not to file an amended petition. And in this case, the post-conviction court knew that counsel was leaving the jurisdiction. Counsel announced this on the record. The trial court made it clear that post-conviction counsel wasn't going to be expected to do any additional work on the matter, but didn't officially allow post-conviction counsel to withdraw and didn't appoint new counsel. Because of all of this, Mr. Malone was effectively denied his statutory right to counsel under the Post-Conviction Procedures Act. That's specifically 4030-107B. So therefore, we're asking this court to reverse and remand the post-conviction court's denial of Mr. Malone's petition for DNA testing in order for the trial court to appoint counsel to file an amended petition on his behalf. Now, Mr. Malone filed, in this case, a pro se petition under the Post-Conviction DNA Analysis Act. This pro se petition was 23 pages long, including attachments, and much of the petition did appear to be sort of a form petition summarizing some of the case law around the Post-Conviction DNA Analysis Act. Now, Mr. Malone did write, and it was clear that this was Mr. Malone's work. Petitioner has 3 exhibits, A, B, and C, showing the DNA has been done in this case, and there's nothing that puts Petitioner Malone on the scene of the crime. That's page 12 of volume 1 of the technical record. So this argument in and of itself, that his DNA was not on the crime scene, does not support new DNA testing. This is a sufficiency argument that has already been adjudicated, so we concede that. However, much of Mr. Malone's pro se petition does cite to the Tennessee Supreme Court case Powers versus State, which stands for the proposition that petitioners under the DNA Analysis Act should have access to a DNA database to establish the guilt of an as yet unidentified third party. And then Mr. Malone also attached a TBI serology and DNA report, and that report listed several items where DNA analysis had been either not performed. There were some items that were not tested, including a towel and a floor mat. There were some items that were tested where it would have been reasonable to request additional testing or retesting, such as the shotgun that was the murder weapon in this case. And there were some items tested that had other DNA profiles that excluded Mr. Malone and his co-defendant and the victim that could have been uploaded into a DNA database under Powers in an attempt to identify an as yet unidentified third party. So under Swanson versus State, a pro se petition is supposed to be held to less stringent standards than formal pleadings drafted by lawyers. And the petition in Swanson is described as, well, the petitioner is described as having a limited ability to make a cogent legal argument. So I think the courts do understand that these pro se petitions are not always artfully drafted. And in this case, the trial court did not dismiss Mr. Malone's petition upon preliminary consideration, which the court could have under the Post-Conviction Procedures Act if it reviewed the petition and found that there was a failure to state a factual basis for the grounds alleged, but the court didn't do that. And the court instead appointed Mr. Malone counsel on January 13th, 2023. And then once counsel was appointed under the Post-Conviction Procedures Act, counsel was required to either file an amended petition or file a written notice that no amendment would be filed after conferring with Mr. Malone and Mr. Malone agreeing that that was the appropriate course. So the reason this didn't happen, it appears from the record, is that on May 31st, 2023, post-conviction counsel told the court he would be leaving Shelby County next month. That's volume 2, pages 9 to 10 of the record. So then the post-conviction court said it would review the pleadings and decide whether there needed to be a hearing on the petition or whether it should just enter an order dismissing the petition. Then on the next status date, June 26th, 2023, the court said it needed more time to review the pleadings, and counsel reminded the court that he wouldn't be present going forward. So at this point, I'd submit that the court should have let counsel withdraw and appoint a new counsel.
But at that junction, if the post-conviction counsel had filed either an amended petition or a petition that says we're good with this, the original, then we wouldn't be here arguing today? Is that your position, at least on that issue?
Yes, on that issue, we would not be here because I assume that counsel would have either worked with Mr. Malone to draft a petition that, clearly stated, the grounds under which he was entitled to relief under the DNA Analysis Act.
Okay.
Or if Mr. Malone agreed that no amended petition should have been filed and submitted to the court for its ruling, I think we would be not in a position where we could raise this issue.
So if the trial or post-conviction court had never appointed that counsel in the first place, we wouldn't be here arguing this issue, because the court can do a preliminary review and dismiss.
Right. And I would also argue in the alternative that Mr. Malone's form petition in and of itself could be read such that summary dismissal would not be appropriate,
Okay.
and that it could be read to meet the 4 elements of the DNA Analysis Act. But I think it is a much stronger argument because the court did appoint counsel initially, and at that point, you would assume the court has conducted the preliminary review and decided that there is enough of a factual basis to go forward.
I understand your argument.
Thank you. So then on June 26th, the court basically said, I'm just going to leave you on the case to post-conviction counsel, and told him to remind the court to relieve him if the case wasn't resolved by the next court date, July 31st, 2023. And then the transcripts show that the case was reset without any discussion on July 31st. And post-conviction counsel was never officially relieved. He never filed an amended petition or written notice that he wasn't going to file an amended petition. And I'd submit from the transcripts in the record, the trial court made it quite clear that the court didn't expect counsel to do those things. And then on November 7th, 2023, the court entered an order summarily denying Mr. Malone's petition. So again, I do think what's significant here is the court didn't dismiss the petition upon preliminary consideration. The court did decide to appoint counsel. And while there's no constitutional right to post-conviction counsel, there is that limited statutory right to post-conviction counsel under the Post-Conviction Procedures Act if the petition is not dismissed upon preliminary consideration. So once the court made that initial determination that Mr. Malone was entitled to appointed counsel, he was entitled to that counsel to either file an amended petition on his behalf or file a written notice that no petition would be filed. So our position is that with the assistance of appointed counsel, Mr. Malone's petition would have been amended to include a much more coherent, cogent argument that he was entitled to DNA testing under the 4 prongs of the Post-Conviction DNA Analysis Act. And then, Your Honors, I did raise some additional claims in my brief. I did also argue that the court should have made findings of fact regarding all 4 of the requirements in the Post-Conviction DNA Analysis Act. The court only addressed factors 1 and 3 in its order. It didn't address claims 2 and 4. And there are cases, Downs versus State, Nelson versus State, that say the court, it's preferable for the court to address all 4 requirements because that facilitates proper appellate review. In claim 2, I mentioned that the court erred regarding factor number 3, finding that evidence was previously subjected to DNA analysis. I understand the court was referring there to Mr. Malone's argument that there was no DNA found on his clothes. But taking the petition as a whole, with the language from Powers and the TBI report that was attached, it is clear from that TBI report that there were items that were not subjected to analysis. There was the shotgun, which could have reasonably been sent off for additional testing or retesting. There was a partial profile found on the shotgun. It's possible that retesting would have generated additional DNA evidence from the weapon.
But at trial, as I recall, all the DNA evidence was beneficial to your client.
Yes, so the fact that there was no, the victim's DNA was not found on Mr. Malone's clothes was absolutely beneficial to him, and that was presented at trial. I think under the DNA Analysis Act, some of these items, if they had been submitted for retesting, could have potentially suggested that, alternate suspects were involved, if there was someone else's DNA on the shotgun, if there was someone else's DNA on this $100 bill that had other DNA profiles on it. And of course, we don't know this, we can't know this at this point, but the language in Powers versus State does say that the court must presume that testing results would prove exculpatory to the petitioner in conducting this analysis. And of course, DNA testing is not just limited to cases where there's only tenuous evidence supporting the jury's finding of guilt. And the fact that an appellate court thought there was strong evidence to convict is not determinative. So even though Mr. Malone did present the TBI report to show that the victim's DNA was not on his clothing, there could potentially have been additional items tested that could have potentially exonerated Mr. Malone or suggested that other parties were more responsible. And Your Honors, unless you have questions regarding any other aspects of the briefs or these issues,
Thank you, ma'am.
I'll reserve the remainder of my time. Thank you.
Yes, ma'am. General?
Good afternoon, Your Honors. May it please the court, Ray Lapone on behalf of the state of Tennessee. This court should affirm the judgment of the post-conviction court. The state respectfully disagrees with petitioner's counsel that although the post-conviction court was not required under the Post-Conviction DNA Analysis Act to appoint counsel, it was discretionary. The fact that the court did that and appointed counsel does not convert this very narrow area and avenue for relief into counsel that's required at a proper post-conviction petition. So we disagree with petitioner's counsel as it relates to that issue. The court in this case actually went above and beyond. It did appoint counsel and it didn't have to. There was counsel appointed who notified the court that he was moving to another jurisdiction. So the court said, okay, let me review this petition. It's proper for the court to take a look at the petitions because the purpose of this act, as this court has said, it's an additional method, a limited scoped avenue for relief, essentially another type of claim of innocence through DNA testing. So this isn't your ordinary post-conviction petition. This is a narrow avenue of relief, and that's why the 4 requirements exist that are, frankly, a state's position are very difficult to meet. So in this case, the post-conviction court did everything properly.
Doesn't the appointment of counsel after the filing of the original petition, if nothing else, doesn't it shows that the trial court has looked at it And if I'm willing to appoint counsel, then maybe there's something to this other than just the preliminary review and dismissal.
No, Your Honor, I think in this case, based on the record, the post-conviction court just went ahead and appointed counsel.
Without reviewing the petition.
Yes, because at that time, and I think the record will bear this out, they all showed up for a court appearance after she had appointed counsel, after the post-conviction court had received this petition. And I believe the record will bear this out, that the court addressed the attorneys and said, okay, let me review this because we now know counsel may be moving. If I review this and to make a determination that it requires or warrants an evidentiary hearing, then I will appoint him counsel. At that point, that counsel could file an amended petition, they'll have a hearing, and they'll look at the claim that the petitioners filed.
I'm not doubting that that's what the trial judge did here. I'm just asking it this way. That doesn't seem like the common practice.
It's not. In fact,
The common practice really is to review them, and if they think there's something to it, then appoint counsel.
absolutely, Your Honor. And I think Judge Easter's question, it's an interesting argument here to make because if you go with petitioner counsel's argument, then the post-conviction court giving a pro se petitioner counsel on one of these types of petitions is now all of a sudden going to create an appellate issue. Because, petitioner counsel responded to Your Honor's question that we probably wouldn't be here if the court just wouldn't have given the petitioner counsel. And so the state's position is that the post-conviction statute, as it stands, that's if you're going to file your standard post-conviction where you've got constitutional claims. It's absolutely different than this very narrow avenue of relief, which we'll get to in a minute as it relates to these 4 requirements. So it's kind of a gatekeeping function that the post-conviction court's keeping. We want our judges looking at these very closely because it's very difficult to get relief, to get additional DNA testing under this act because you have to meet all 4 requirements.
Well, let me ask you this before I forget my thought.
Yes, Your Honor.
Usually when these petitions come into a clerk's office and comes to the post-conviction court for a preliminary review,
Yes.
that results in a preliminary order which appoints counsel, correct?
It could, yes, Your Honor.
Did it here? Is there an
No.
order in the record that says that preliminary order, find that this has some merit, I appoint lawyer X?
No, Your Honor. I believe in this case, the post-conviction court got the petition, gave the petitioner counsel. They had a report date. They addressed the petition, right? And properly under the statute, the post-conviction court gave the state an opportunity to respond. So the state filed a response. And then they had the conversation that petitioner's counsel would be moving. And so at that point, the post-conviction court said, okay, let me take a look at the merits of this petition. Let's see if this petition has a prima facie case for relief under the DNA Post-Conviction Relief Act. If so, if we're going to have a hearing on this, then we'll appoint counsel if counsel that's appointed now is going to be moving and has to withdraw. And the state's position is that's what occurred in this case. But more importantly, Your Honors, moving to the petitioner's actual claim and the petitioner's argument that there could be any DNA testing or retesting under this act granted to this petitioner based on the facts of this case, there's simply no basis for that. In fact, if you look at the facts of this case, which are paramount according to this court, when a court's reviewing these very narrow reliefs to order DNA testing in a case, you have to meet those 4 requirements. And based on the proof against this petitioner, there is no way testing anything from this petitioner's crime scene could ever create a reasonable probability that he would not have been convicted or prosecuted for felony murder. So let's take a look at the facts. Not only did he tell law enforcement that he was part of the planning of this robbery and murder, that he actually committed the killing, that he actually took the victim's property, and that he actually left and went back and grabbed additional property. He told police that, and the jury heard that. He also told a friend of his, Miss Dixon, confessed to her that he accidentally killed a truck driver, which we know is not a defense for felony murder. In addition to that, he had the victim's property on him at that time. Then He shows up in front of Miss Banks with the co-defendant, covered in blood, washing blood off of money, with the shotgun, and asked Miss Banks to hide it. The proof in this case was overwhelming. He was even tied to a description of the vehicle from lay witnesses who saw this car with a broken window in the back fleeing the scene after the victim in this case was executed with a shotgun. Why is that important to this case? Because you could test the towel. You could retest a shotgun that was passed around and hidden by a third party. You could test the floor mats. You could retest his clothes, which didn't show any DNA, and the jury heard that. And there's not going to be any testing, DNA testing, that you could perform in this case under any circumstances with those facts that would create a reasonable probability that he would have never been prosecuted for felony murder or that he would never have been convicted of felony murder. And if we move from the mandatory provision to the discretionary provision, there's no DNA testing that could be done in this petitioner's case that would even yield any favorable evidence to him in the outcome or to present as a defense in the trial. In fact, that trial, his only defense was that he accidentally killed the victim and was not a defense for felony murder. And then he put in this DNA serology report that petitioner's counsel is now talking about that he attached to this petition. The jury saw it. And what's interesting, based on Your Honor's question, was, well, isn't it true that there was no DNA tying your client to this scene? That's absolutely true. And the jury heard it, and he was still convicted. So the state submits that even if there was an amended petition in this case, there is no claim that this petitioner has to reach those four requirements. And as this court has said, requirement one is the most important. It's also the most difficult to reach because, as this court has also said, the failure to meet just one requirement is fatal to an action under this statute. So we would submit that Your Honors should affirm the judgment of the post-conviction court if you don't have any other questions.
Thank you, Mr. Malone. Rebuttal.
So first, Your Honors, regarding the proof in this case, there were a number of lay witnesses that testified regarding, I would characterize it as circumstantial evidence connecting Mr. Malone to the homicide. There was some direct testimony from witnesses that I would characterize not necessarily as accomplices, but as people who could be in some way implicated in this offense, like Sheila Dixon, who testified that Mr. Malone admitted to her that he committed the homicide.
What about Mr. Malone's own statements, though?
So-
That's, I mean, I'm not trying to cut you off, but the damaging part is his confession to the crime.
And, Your Honor, it does appear that Sergeant Mullins testified that Mr. Malone was interrogated over what appears to be a significant period of time, given that he gave 4 different versions of events. First, an alibi, basically. Then he said that he and the co-defendant were just at a gas station. Then he said the co-defendant shot the victim, and then he admitted to shooting the victim, which ultimately they got to a confession. But I do think that arguments, could be made that because of the length of the interrogation and the persistence of the interrogators, that one of those original versions of events was the more accurate one. So that's what I would say regarding Mr. Malone's testimony. And I think similarly, the other witnesses that implicated him, Ms. Banks and Mr. Nelson, they really implicated primarily the co-defendant, saying the co-defendant was in possession of the shotgun after the offense. Ms. Banks did say she saw Mr. Malone and the co-defendant washing money together. And then Ms. Dixon, who said Mr. Malone confessed to her, she also confessed when she was being held in custody on a 48-hour hold. And she had been found to be in possession of some of the victim's cards. So I think an argument could be made that she was under some pressure to give an alternate name.
I guess when the standard is charged or convicted, and your client has confessed, whether you can make a great argument to the jury as to why the jury shouldn't believe it, you're not going to be able to convince the police not to charge him based on, or get an indictment based on it, because he's confessed. That's where I think, to me, even if we were even to go down this road,
Right.
your biggest hurdle is.
Right. Well, and Your Honor, because the standard is prosecuted or convicted, I do think that if that DNA testing had been done, there certainly could have been reasonable doubt if any of that evidence suggested that there was anyone else involved, anyone who could be implicated as a third party.
Anything else? Thank you, ma'am. Ms. Obermet, I understand, and Mr. Chisholm too, both of these cases that you've argued this afternoon, you were appointed on, correct?
Yes, Your Honor.
Thank you for taking the appointment.
Yes.
We do appreciate you taking these cases from the various counties in the western section. Thank you.
Thank you very much.
Anything else, Madam Clerk? Okay, we will be in recess until the next call of the docket.
All right.